I can tell that you're not very remorseful, you dope. He didn't try to get you in trouble. They reached out to him and he was uncooperative with them.
This isn't just another drunk driving case. This is a 22-year-old with a .173 blood alcohol level, a rollover crash, multiple passengers, and a judge who is not buying the no one was really hurt narrative. You're about to see a courtroom tug of war over how serious this really was. Was it just an accident, or a felony-level ticking time bomb that slipped through the cracks? Watch how the judge digs into missing medical records, how the prosecutor but admits this should have been charged higher, and how the defendant's own words nearly sink him. As you're listening, ask yourself, is this sentence too light, too harsh, or exactly right for what happened on that Halloween night? Let's get into it.
You crashed your car with a .173 blood alcohol. You rear-ended another car and almost killed two people.
Sir, I understand.
You rolled your car over, Mr. Schuster.
Yes, sir.
This is file number 251687. You were charged with operating with a high blood alcohol level. That matter was reduced and you pled to a charge of operating while intoxicated.
Yes, sir.
This may be the worst case of the day. Daniel Frazine has prepared the screening report, and I feel like I got a complete disconnect. There's a terrible accident where somebody has debilitating lifetime injuries, and I have a recommendation of 1 day jail. Credit 1 day. I feel like I fell off a cliff or something. Mr. Felt, what would you like me to know?
Judge, actually, I had a question, if I may. Was there somebody injured in the other vehicle? Is that who you're referring to?
The police report, supplemental report, says that someone in his vehicle
Right.
Right, and he was,
Yeah, hang on.
has an extensive history of head injuries, nerve pain. And he was suffering from a pre-existing condition, and all of which have been getting worse since the crash. So that was a person in his vehicle. The people in the other vehicle weren't doing too great either. This car flipped over. There were 3 people in it, may or may not have been drunk. They hit another car. Yee.
Judge, that helped me. Thank you.
All right.
Well, what I was gonna say was this. Mason was in Kalamazoo at a Halloween party, was not planning on driving home that night, was gonna stay. He gave a couple other people a ride up there. While they were up there, he drank, and he drank more than he should have, at least certainly to drive a vehicle. But the drinking was up there. And one of his occupants, incidentally the one you referenced, wanted to go home, change his mind, their mind, and wanted to go home, insisted on a ride home. So Mason was stuck in that regard, driving when he never intended to. Now, be that as it may, it's another example of poor decisions and judgments when you've been drinking. But nonetheless, the accident, now, my understanding of what happened in the accident was correctly stated his vehicle went off the road, slipped, etc. But he says none of the 3 of us got injured. He says the one occupant did ask to be examined. So he was ambulanced, I think, to 3 rivers, but only treated and released. So if there's more injuries involved than that, he's never been notified by any insurance company or attorney representing an injured party. So we simply present to you, we're not aware of anybody seriously injured. We are aware that the occupant, his occupant, asked for an ambulance ride to the hospital, was treated and released, and we understood that was the end of that. Now, I don't know whether that enlightens you or adds more questions. But what I would say is this, when you mentioned one other case a while ago being more serious, his came to mind. I talked to him a little bit about it. When I just heard this prior case, I assume that's the one you were referencing, where there's a bad accident, and bad injuries and et cetera. All I can say is in his case, he's not aware of any injuries other than the one occupant ambulanced and treated and released. Now, again, be that as it may, I would point out maybe the redeeming factors here is he did not flee and elude the police. He didn't get into a resisting.
Oh, yeah,
et cetera.
that's true.
So there are some redeeming factors here. I submit to you, we only know this to be an accident because of alcohol, alcohol related accident, and are not aware of any serious injury other than this treat and release.
All right, well, this happened a year ago, Halloween of 2024.
Right.
The affidavit has the wrong date in it. I think this has Miss Camfield's fingerprints on it because she got here and somebody asked the state police to go back and better interview the person in the vehicle. What the police report said, I spoke to Kirsten. Well, Miss Camfield wasn't here yet in February of 25. He went to the hospital to have his head checked. He stated no head scan was done, but his blood sugar was checked. He has an extensive history with head injuries, nerve pain stemming from his neck to his arm. He advised the issue with his neck has gotten worse. And bear in mind, this was February after the October accident. And he now has trouble rotating his head due to his neck pain. He has suffered from pre-existing conditions such as short-term memory loss, chronic headaches, light sensitivity, all of which has gotten worse since getting in the crash. As far as I'm concerned, that's operating while intoxicated, causing a serious or debilitating injury. But it also looks like they weren't particularly cooperative. I don't know that they ever got that person's medical records. So when it was authorized, finally, like in June of this year, all that was authorized was high blood alcohol level and operating while intoxicated. There was no felony charge of operating while intoxicated with a serious injury. So this is what we got. But the police report, when they went back and re-interviewed the victim, and this has been a sore point of mine for some time. It's better now once Miss Davis came, but they would have a bad accident and then they would never, passenger was removed by ambulance and they never checked to see what happened to the person. Then you find out they've got terrible debilitating injuries, and this happened multiple times in the last several years. So I didn't know if that's what this was. So it happened in October. They asked for further investigation. That has Ms. Davis's fingerprints on it. She took office in December, and this would have been a case that she would have inherited from the previous administration. So she or somebody, Mr. Gabry or her, asked the police to do some more investigation, which they did. Then several months later, Ms. Camfield authorized this. It also appears that that witness and his parents were not particularly cooperative with the prosecutor. But it is a situation where he crashed into somebody else's car, rolled his car over with 2 people in it, and could have killed 5 people. And his blood alcohol was over the high limit for high blood alcohol level. He also has some prior criminal history, and he's only 22 years old. So with that, maybe we'll get enlightened more from the prosecutor. But reading the police report, this looked like a 5-year felony. instead of a 93-day misdemeanor, but the prosecutor has the discretion to do the charge and the plea offer, and they know more about the case than I do. And we always have to remind ourselves of that.
Here's where the legal tension really spikes. The judge is basically saying, on paper, this looks like a 5-year felony DUI with serious injury, but all we've actually got is a 93-day misdemeanor OWI. Why? Because the formal charging decision is based on what's provable with documents and records, not just what the accident sounds like. Missing medical records, delayed follow-up, and uncooperative witnesses mean the prosecutor didn't have a clean, felony-ready package. This is a great example of how a case that feels morally severe can still be legally constrained. What do you think? Should prosecutors file more serious charges and risk losing at trial, or stick with what they can confidently prove and secure conviction?
So with all of that, Mr. Felt, go ahead.
That basically, all I was pointing out to the court was my client wasn't aware of any other injuries if they did happen. And he hasn't been, it's been quite a while, as you pointed out. He hasn't been contacted by anybody suggesting.
Well, the kid said, we don't consider him to be a friend anymore. So I don't think they had any further contact after the accident.
I'm only pointing out he hasn't been contacted by anybody suggesting an above threshold injury claim. That's
Yeah,
all.
so there was no insurance claim or anything made.
Correct.
Okay. All right. Ms. Canfield, what's your thought here?
Well, Your Honor, what I can tell you, I think we were in the midst of changing our computer storage systems for these cases, and I now see supplemental reports that the court is referring to that were not available to me at the time of charging, or I very likely would have charged this at the felony level. That being said, it was a serious matter. There were apparently for that passenger that was injured pre-existing conditions that may have been made worse, and that would be perhaps one of the difficult things to differentiate at trial as to what was pre-existing and what was the actual injury from the accident, although you do somewhat take your victim as you find them if you make a condition worse. I do think that a period of probation with the victim impact panel and alcohol monitoring is definitely in need here. I do also think that we should reserve restitution for any of the individuals who were injured or whose vehicles were damaged if there's not a suit that's going to come forward. He has 2 prior criminal charges, leaving the scene of an accident, and controlled substance use, which is also concerning. I frankly think that because of the severity of the injury and the fact that it wasn't charged as a felony, this is another instance in which 30 days of jail would be appropriate in addition to the community service that's recommended. I mean, there has to be more than an overnight while you're intoxicated wake-up call in these types of instances. It could have, we just had a serious accident on 131 southbound in Kent County or Allegan County, I guess a little bit further south, where 4 people died. And obviously in these accidents that can occur, particularly if a vehicle flips. So I do think that the jail is warranted if we've overcome the presumption of fines and costs in this particular matter. And I would ask that the remainder of the recommendation of Mr. Frazine be followed.
Daniel, what's your thought?
Well, I was very concerned about, obviously, anytime you rear end someone when you're drinking is bad. Then, as near as I could tell, and from the information that I had, they couldn't really determine whether what was caused from this accident, what was predetermined. There's bad blood between both parties. One says it's his alcohol, one says it's not. One says they're both saying they're not each other's friends. So it's bad blood going back and forth, which fuels stuff. And obviously, you get an accident like this, that would cause you to be upset. obviously. So, and I think part of it is we do get kind of desensitized after a while. You think, well, it's not a felony. I mean, 173 is high, but we're so used to getting so many high ones now. Do I think that jail could be obviously a factor in here and be applicable? I do. I think probation is huge. He's very young. I kind of structured the community work service for a couple of days, and actually it should say 16 hours because I know we use it 8 hours a day, which would be the equivalent of 2 other days in jail. He made a really poor decision. He's lucky he's not dead. He's lucky that no one else is dead, and he rear-ended, and it is serious. And like I said, but as far as the injuries, as near as I could tell, there's nothing concrete that I had that said, well, yeah, this accident caused it. Now, is there a little likelihood? Yes, there is. But I didn't have anything that's saying, and I didn't think the follow-up was all that detailed. And like you said, we do have some issues with that. It's getting better, and I'm hoping.
This is the emotional turning point of the hearing. The defendant says he's sorry, but instead of sticking with accountability, he pivots to blaming the injured passenger and questioning his motives. In DUI sentencing, judges don't just listen to the words, "I'm sorry." They watch how you talk about the people you put at risk. Here, the judge hears a man more focused on whether someone is trying to get him in trouble than on the fact that he rear-ended a car, rolled his own vehicle, and nearly killed multiple people. That's why the judge calls him out so sharply. For you watching, ask yourself honestly, if you were in the judge's position, would you read this as genuine remorse or as damage control? And how much should that perception influence the sentence someone gets?
Continues to get better with a follow-up on that, because it would have been nice to know if there was definitely some injuries that were caused of this, but this is my recommendation. I would totally understand the court added more jail days.
Mr. Schuster, what would you like me to know? Is there anything you'd like to
I'm
tell
sorry,
me?
Judge, I am distracted.
No need for apology. You were talking with your client. That's appropriate. Mr. Schuster, is there anything you want to tell me?
I just wanna say I'm truly sorry about what happened. I mean, I understand the severity of it, but it's been over a year. I don't drink anymore, or I hardly do. I drink on occasion. Back when the accident happened, Kirsten or whatever his name is, he told me that he was released the same night. He was beat up by the police 2 years prior because he had fled and eluded and done this and that, which is what caused the nerve damage. That's what caused the nerve damage. I was never told that he was more injured or anything from that. I truly believe he's just doing this to try to get me in trouble because he's upset with me.
All right, I can tell that you're not very remorseful, you dope. He didn't try to get you in trouble. They reached out to him and he was uncooperative with them. You crashed your car with a .173 blood alcohol. You rear-ended another car and almost killed 2 people.
Sir, I understand.
You rolled your car over multiple times with a couple people in there. And your response is, he's trying to get me in trouble.
No, that's not what I'm trying to say, sir.
It's what you said. It shows you don't have any remorse. So before you dig your hole any deeper, what else would you like me to know?
I just would like you to know I truly am remorseful for what happened.
Let me repeat. You hit a car with 2 people in it. You rolled your car over 3 times with 3 people in it. Your blood alcohol was 2 times the legal limit. It took a year or about for you to get arrested on this. In February, the new prosecutor inherited it, asked for more information, which we didn't completely get. We didn't check with him either, apparently. The affidavit says he advised of lasting effects from the head injury. And then there was the follow-up, and then the follow-up got lost in the shuffle or something. So what I said is I feel like I'm in the wrong universe. we had the young boy from El Salvador, who's a two-something, crashes his car, leaves the scene of the accident, runs a stop sign, fights with the cops. The next man is a 289. He's 57 years old. He's an Indian immigrant. He crashed into a car, left the scene of the accident. And you crashed into a car, injured the people in your car. And well, this happened a year ago. Sometimes it takes a long time for these to get authorized. I don't know all the circumstances. Some had to do with the change of office. Once you got arrested, you've been cooperative. But this ain't a 1 day in jail credit, 1 day. Unless I might as well retire and go 10 roses or something. So I'm not sure what is the right answer. You're 22,
23 years.
23, but you do what 23-year-olds do. The young boy from El Salvador went out and got drunk and then drove his car. It's like, well, of course. You drink way too much at a party, and then when you get to that point, you lose your judgment. It's like, well, I can drive. You had to drive all the way from Kalamazoo to where you were, where you finally crashed into the back end of this other car. We've had a terrible year of accidents on 131. Ms. Canfield just remarked to the one that happened in Allegan County within the last 14 days where 4 people were killed. This guy isn't going out of his way to get you in trouble. What it says, as far as I can tell, nobody ever got his hospital information. Prosecutor requested additional information from passenger Kirsten Richards regarding current medical condition, and all passengers from both vehicles need to be interviewed. That's either Mr. Gabry or Ms. Davis in January, right after they took office, saying, hey, this case needs some more work. Kudos to them. In February, contacted Kirsten's parents to receive call from him concerning his medical status. Parents seemed to be uncooperative. Contacted parents of subject taken to hospital after crash. Interview a subject requested by the prosecutor's office. So they wanted to know what the guy had to say. And he says it's all gotten worse since the crash. But it wasn't like he was like, hey, please interview me. Now, who's this? Anything else that you want to tell me?
Not much, sir.
Are you working somewhere now?
Yes, sir.
All right, where is that?
I'm working for my father doing home repair. And,
All right, that's what he
remodeling.
said. You do drywall?
I do everything, really. That's for sure.
Well, you're going to lose your driver's license as a result of this. There's nothing I can do about it.
I understand that.
But I agree, a probation is needed here. We'll do a 24-month probation, which can be discharged at the end of 12 months. I'm going to order 11 days, credit 1, leaving 10 days to serve. Should be served on the weekends. I'm supposed to do these sentences proportionally. And according to the Auburn Hills Court of Appeals case, I'm not exactly even sure what that means. It is your first drinking driving offense, and it did in fact not get charged as a felony. In fact, they even reduced it from high BAC. So it's just a regular OUIL first offense. There's this $300 fine, $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee. You hired your own attorney, $960 probation oversight fee. Ms. Canfield, do you have a police reimbursement in your file?
I'm not seeing one, Your Honor, but it would be to Michigan State Police for a blood test and an accident.
Before we wrap, let's break down what this case ultimately shows us. A dangerous crash, conflicting accounts of injury, a defendant struggling to express remorse, and a justice system trying to make sense of incomplete information. The judge had to balance the seriousness of the accident with the limits of what was officially charged, and in the end, he imposed a sentence aimed at accountability, rehabilitation, and public safety. This case is a reminder that one night, one choice, one drive can spiral into life-changing consequences. And it also raises a bigger question. How many DUI cases slip through the cracks because crucial evidence never makes it into the file?
The other one I just did $200. Drinking driving is an expensive proposition, Mr. Schuster. There's a commercial that says that, and it certainly is true.
Yes, sir.
$300 plus $125 plus 100 screening fee, $960 probation oversight fee. That could be cut in half if you do it in a year. $200 police reimbursement and a $32 victim impact fee. And if we subtract $480 from that, it would be about $1,237. You need a timeout. You don't really realize it. You feel like you got beat up over there, but you dodged a great big bullet.
Yes, sir.
Not the least of which is 4 other people didn't get killed that night. And they didn't charge you with a felony. We have about 8 of those cases pending. Several deaths. We probably have 5 drinking, driving with a death case pending. A couple more under investigation. 5 from this year. A few more where there's a serious debilitating injury. One person was charged with murder, second-degree murder. I want you to go with Daniel for this probation, and I want you to comply with it. No drugs, no alcohol. Test as directed,
Yes, sir.
including no marijuana. I don't know if you're a recreational marijuana user, but you can't use it. We're going to test your blood periodically. We're going to get an assessment. You're going to go to the victim impact panel. You're going to pay me about $1,237 in the next year. All right. And you can't drive. And don't get another one of these or you'll really get on the merry-go-round.
No, I can assure you,
All right. Very good. You're good to go.
thank you, sir.